All right, now I show not even the placeholder. I just show a.
No, we're live now.
Okay, there we are.
Yes, we're live now.
Okay.
So, good evening, everyone. Thanks for bearing with us during the start. We're only 3 minutes late here. I'm Ed Levine, Social Media Director and Executive Member at VCDL. And I'm joined tonight with Pat Webb, our Secretary and Treasurer, Philip Van Cleve, our President, and two of our illustrious Virginia gun attorneys, John Pierce and Gilbert Ambler. And the goal tonight is just to go over some of the questions that we get via the website and via email on legal questions about guns in Virginia, just to give you some general information on questions that you may have or people ask us all the time about things that's going on. So keep in mind, while these gentlemen are attorneys, they are not retained by you, and therefore they are not your attorney until you have that relationship with them. But for general questions, they can pretty much tell you what's going on. Anybody else want to say hi before we jump right in and get started?
Yeah, we'll certainly welcome everybody on. This is a great opportunity for those of you that have had questions burning in your mind to get an answer from an official source.
Happy to be here.
So it looks like we got our first question from Wrenchhead, who's asking, with the interchangeability of the parts on AR-15s, if one was to install a 300 blackout upper on a lower marked 5.56, are there any laws requiring the lower to be remarked?
So the answer is no on that. When you look at the marking requirements as they exist today, I know one of the things we'll probably be talking about is some of the proposed regulatory rulemaking, which just kind of throws the kitchen sink at this topic. But the requirements are very simple. When a manufacturer makes a firearm component, specifically the framer receiver has to be marked with the manufacturer information. It has to be marked with a model number, a serial number, and then it needs to at some point be marked with a caliber. But if it is in fact a multi-cal lower, it can be marked multi, or it can be marked with what they consider to be the primary configuration. If you get a 300 blackout upper, for example, the upper itself is probably going to be marked 300 blackout, but the marking requirements for the lower, which is the part that is required currently to have that marking, doesn't change just because you're using a different upper. That might in fact change how the lower functions. The primary configuration of that lower is still 5.56, even if it's being used in a different manner as an alternate configuration.
Yeah, and Wrenchhead has some money there if he's busy shooting a lot of 300 blackout. By the way, I have a question that somebody had emailed me, and let me take my glasses off so I can see. I look forward, let's see, he's mentioned looking forward to talking to you guys. I have a question that has been on my mind for a while that I hope you'll ask. I've seen and read in a few places not to use your hand-loaded, reloaded ammo for defensive carry. Why should we not use our reloaded rounds versus factory rounds? What are the legal aspects of this? Thank you.
I think that the short answer here is, why roll the dice on giving the prosecution something else that they could use against you? Because it's naive to think once the prosecution decides they're coming after you, that you've done something wrong, they're charging you with a crime. It's naive to think that they're not going to use everything available to them against you. And that includes hand loads or reloads. If you're reloading your own ammunition, they're going to be attempting to bring that up and talk to the jury about what you have done. And they're going to be trying to argue that that shows something about your intent. The fact that you were out there hand loading ammunition. And frankly, even if they can't prove something about your intent with it, to a lot of people that might sit on the jury, it's going to make you sound, and this is going to be the way they're going to think of it. This is not my terminology. They're going to make you sound like a gun nut. And there's a lot of people on the jury that are going to be turned off by that. And so my recommendation is strongly, if you're going to hand load, use that for practice, carry factory ammo for a defensive purpose, because there is absolutely no reason, with all the very, very good factory ammo that is on the market, and I know it's tough to find right now, but there's a lot of good options out there. Carry factory ammo. Now, John and I were discussing this earlier. There's always going to be arguments about admissibility of evidence and whether the prosecution can actually get something into evidence against you. And that's a legal argument that can take place. But the answer, and I come back to the same answer on this, is why roll the dice? Because even if your lawyer has to make that argument, it's going to cost you time and it's going to cost you money. And there's no guarantee that your lawyer is going to be successful in keeping it out. So take the safe route, carry factory ammo.
So Gilbert, would there be any advantage? I assume I'm allowed to ask questions. Is there any advantage to saying, well, the ammo that I'm using is the same one that Chesterfield Police Department uses, something like that?
Yeah, I do think so. And again, you have to expect the prosecution to use everything that they can think of against you. So the prosecution may attempt to spin that, and they might try to make it sound like you were trying to take a law enforcement function with what you were doing. I carry ammunition that is consistent or the same as what law enforcement carries on a regular basis. I think that that is something that if the prosecution tries to take that tack, we can explain, and we can do this through expert witnesses, why that ammunition is the best choice available, because that ammunition is the most effective at stopping the threat and then not over penetrating and stopping and hitting something behind the threat. And if you are in a defensive shooting, you're not saying I wasn't trying to shoot somebody. You're saying, yes, I did it. I had to do it. I did it on purpose. I wanted to stop the threat. And so your choice of ammo is going to be consistent with that. And we can explain that.
But it would seem like what you're saying, it might be better maybe not to bring that up unless the prosecution brings it up.
I think that the facts of each individual case are too specific. I think it may factor into your overall trial strategy, but it's going to be dependent on the facts of each individual case.
And Gilbert and I were talking earlier about this very topic, but again, so far we've focused on criminal prosecution. Let's assume that the prosecutor fully agrees that the particular shooting you were involved in was justifiable self-defense. However, one of the rounds passed either through an attacker or in fact missed the attacker, and a piece of shrapnel ended up, say, striking someone's pet dog. And then they wanted to raise the issue of if you had been using factory rounds as opposed to hand reloads, you would have had a different type of bullet, a different cast of bullet. There's also civil liability issues that would have similar things. And again, it comes back to what Gilbert said, why hand someone a hammer to hit you with?
So now I see a question up on the screen that seems directed straight to you, John.
I'll take that one. Yeah, I just see that now. How do I start a gun trust? I'm going to give you a blatantly a blatant advertisement here. Give me a call. Sometime after this meeting or tomorrow. It takes about 10 minutes. I walk you through the various people who are part of the trust.
John, for those that don't know, maybe you could explain what a gun trust is and why someone might want one.
Sure. So a gun trust is a rather generic term that we use to refer to a trust that holds firearms, accessories. But 99% of the time when people are doing these, they're specifically using them to hold NFA items. NFA items are distinguishable from regular everyday firearms such as ARs and pistols and rifles and shotguns, in that they're one of the regulated items under the 1934 National Firearms Act, as amended in 1968 and again in 1986. Suppressors, short-barreled rifles, short-barrel shotguns, machine guns, destructive devices, things of that nature. And so anyway, those items have regulations that differ significantly from regular firearms. One of the most common questions that I often get asked, and I'm sure it's true for Gilbert as well, is, well, I didn't buy this gun at a gun store, so it's not registered to me. And we have to remind people, For regular firearms in Virginia, we do not have registration. Despite the best efforts of the anti-gunners to this point, VCDL has continued to push back against those efforts. And it's a good thing that we don't have that. But that's not true for NFA items. Those are, in fact, registered at the federal level in something called the NFRTR, the National Firearms Transfer Registry. And those items, let's say that a friend of yours comes over, they're getting ready to go on a dove hunt. They want to borrow your dove gun, and you grab your shotgun, you give it to them, they go to the dove hunt, they come back. No money changes hands, even under Virginia's current universal background check law, which I know we'll talk about more later. That's a perfectly acceptable sharing of that item. The way that the regulations are written federally for NFA items, that's not possible to do the kind of normal sharing that we do with regular firearms for NFA items if you own them individually. I mean, with just a strict reading of the regulations concerning NFA items, if you were an individual owner of those, you're the only human being except for a licensed gunsmith that should be handling it until you pass away. With a trust or an LLC or a corporation, all of which are non-individual ownership, you can then have multiple responsible persons and multiple people who can have some form of access to those items. And that's what a gun trust does for you. And so, anyone who's interested in discussing that further can give me a call. My number is 276-206-9615. And in about 10 minutes, I can help you structure one that will help you accomplish your goals.
Good. Another question that we get asked all the time is giving or gifting firearms, especially now with the laws changing with background checks, required background checks and whatnot. And that there can't be anything like, I'll give you this gun and it will be free, no money exchange, but you got to cut my grass for a year, anything like that. So what's the rule on giving away guns?
Yep. So that's an exchange for value. When someone says, I'm going to cut your grass for it, or I'm going to put a roof on your shed, once there's a value received, it's subject, generally speaking, to the new universal background check law, with a very, very narrow exception that's in place until December 15th of this year for people between the age of 18 and 20. And that's really thanks to VCDL's efforts that exception is currently in place. As far as gifting firearms, another thing that we ought to be aware of is, again, a gift is generally permissible. A true gift where nothing of value is received is permissible, but you still need to make sure that you're complying with federal law. And that means you're not gifting the firearm to someone who is prohibited from possessing it. If you've got a reason to know that they can't own it, you see them using marijuana, you know that they live out of state, they're not necessarily prohibited from possessing firearms if they live out of state, but the transfer is still prohibited under federal law. So a gift to an in-state resident that is not otherwise prohibited is generally permissible.
So a gift to somebody that's out of state can still be given, but it has to go through an FFL in the state of their residence.
That's correct. A straight gift directly to the other person is where that becomes an issue. Now, there is a provision under federal law for a temporary loan to a resident of another state for a sporting purpose. And that is also a narrow exception, and something that, frankly, the chances of getting yourself in trouble, you've got a friend that visits from out of state and they've got a license to carry firearms that is recognized in Virginia, and you want to loan them a handgun. Is that a loan for a sporting purpose? Well, it may not be. The chances of actually getting jammed up and being prosecuted for it, I think, very, very low. But it is worth being aware that the federal law allows the loan for a sporting purpose. That's the language of the law.
Let's see, got some other questions rolling through. And this is one of those questions like that I talked about at the beginning, that talking on YouTube to a couple of attorneys aren't going to answer all the questions that you need to know. But basically, William Silverthorne said, I've seen a lot of people accidentally get approached by protesters. I'm at a stoplight and I'm wearing my sidearm and they proceeds towards my vehicle. What action should one take? There's so many paths of questions to answer that. But if you want to take a stab at it and just in generalization.
Sure. You mind if I take two in a row, John?
Go for it.
All right. Well, I always sort of joke with people that because I get a lot of people that call me up or talk to me that want to get the answer that yes, you can shoot somebody. And you're never going to get me to say, yes, you can shoot somebody. There may be situations and facts that help support a justification. And those might be positive if we have to defend you, but I'm never going to tell you absolutely you can. This situation where protesters are approaching the vehicle is a very dangerous situation because it can escalate very, very rapidly. We've seen it escalate very, very rapidly. And I think the laws, frankly, are a little bit behind the times because when they wrote these laws, they weren't necessarily envisioning a situation where people were confronting the mob mentality, which is what we're seeing in common self-defense actions these days. That being said, in Virginia is very suspicious of any defensive action that could be perceived or looks like it may have been about defending property. And so if this looks like these protesters weren't hurting people, they were just damaging the paint on cars or putting out some headlights, and they're not actually getting into anybody's cars, they're not hurting anybody around you, they're not even threatening the people around you, they're just damaging vehicles. That could be a very, very bad reason to even brandish a firearm in Virginia. And so you'd have to be very, very careful in that situation.
Good, thanks. And I'm not hearing an echo on Gilbert.
I'm hearing an echo on all of you. I guess maybe if you're not talking, try muting yourself. See if that stops the echo.
Maybe. So the next question that I see here is from Michael Durig, and he asks, as a firearms seller, does selling a gun to a husband for his wife constitute a straw purchase? Military spouse can't purchase a firearm in Virginia because she isn't included on PCS orders.
So I'll take that one. First of all, that is a correct statement of a problem that a lot of military families have, where military are in a unique situation in that they have a home of record, and in that state they are considered residents for purchase purposes. And in the state where they are on permanent orders, they also are considered residents for purchase purposes, but spouses are not included on that. It kind of circles back to the gift question earlier a little bit, and there's some overlap there in that, is the military spouse purchasing the firearm? Is the member of the military purchasing the firearm for their spouse as a gift, or are they being given the money for the firearm? That is really the legal distinction of a straw purchase. Some of us are old enough to remember a Christmas about, 20 years ago, I guess, when Miss Brady had bought a hunting rifle for Christmas for her son. And a lot of people really took her to task for it because they were really beating the drum about straw purchases then. And even some of the people on her side of the aisle were asking her how she could do that when the firearm was for someone else. And she was trying to explain to them our side of the coin, which is this is in fact a bona fide gift and it is perfectly legal under the law. And the long and the short of it is, if I am, as a member of the military, want my spouse to have a firearm and I'm going to pay for it with my own money, I am going to go down and I'm going to buy it, and I'm buying it for the express purpose of gifting it to her for no other reason than love and affection, then that is not a straw purchase. If my spouse, who has their own income, comes to me and says, here's $500, go get me a gun, that's a straw purchase. And as a seller, you're limited in how much you actually know. As the ATF will often tell you during compliance inspections, your staff should be listening to conversations that are occurring in the store and acting on cues that happen, but you have to go based upon what you know at the time and what you feel comfortable doing. But in general, that would be an acceptable gift purchase.
And I think the point to make there too is it doesn't matter that the person, the spouse in this case, that gave the $500, it doesn't matter. They're perfectly allowed to have that firearm. They can legally have it. It's still a straw purchase, even though they were, not a criminal in possession.
I think there's two things to also take into consideration here. There was a case not too long ago where a police officer bought a gun using his police discount for his father, who was not a police officer and not eligible for the police discount. So that was deemed a straw purchase. But the military spouse now in Virginia, as of last year, the law changed where Virginia recognizes dual residency. So if they can show a lease or property tax bill or something that shows they are also a resident of Virginia as well as their home state, then they can legally buy the gun in Virginia, even though they're not military stationed here.
And just to be clear on that, and that's very true, Pat, but just to be clear, relating to that case where the police officer used his discount and sold the gun to his father, I thought it was his uncle. It may have been his father.
It was his uncle, actually. It was definitely uncle.
In that situation, the issue was he received money in return for it. And as a matter of law, that's where he crossed the line.
Okay.
There's a question on there about brandishing. It says
So,
a friend put a BB gun on
If you'll
her
let me
dashboard.
hit two back to back as well, Gilbert, I'll hit this one. I'm actually currently defending someone who is charged with being a prohibited person in possession of a firearm. And that has nothing to do with brandishing, except to say I've been wading through case law very recently. And one of the cases I literally read earlier today from the Court of Appeals specifically noted that unlike the brandishing statute, which is concerned with the mere appearance of the presentation of a threatening item that appears to be a firearm, in order for possession by a prohibited person to be proven, they actually have to prove that it is an item that was designed, manufactured, and intended to expel a projectile by reason of a explosion or combustion. And so the first part of that is really what goes to brandishing. The question mentioned a friend put a BB gun on her dashboard when she was being berated by a motorist. A starter gun, a BB gun, it doesn't matter. If you are displaying in an ostentatious or threatening manner an item that a reasonable person looking in from the outside would believe is a firearm, then you have a really good chance of catching a charge of brandishing. And so do not expect the reality of what the item is to save you. A lighter shaped like a firearm waved around in the dark is a very realistic predicate for a brandishing charge.
There are a lot of people that think that you actually have to touch it or wave it or whatever to brandish. Like you pull up to the guy in traffic and you're like, "You want to cut me off again, buddy?" And pull your shirt back. And like, "I never touched it."
Sure, absolutely. Because what we're worried about is, did you have the firearm on your person, even if you're not holding it, not in your hand, and doing something that reasonably causes fear in the mind of another? And if they can prove that, and again, as John's saying, it doesn't even have to be a firearm. It just has to reasonably cause fear in someone else's mind where they perceive it as a firearm. That's enough, at least for the brandishing charge. Now, whether they can win a conviction is often a different matter, and obviously very, very back dependent. But that's going to get you charged with brandishing. And I'm going to issue, John had a shameless plug earlier about the trust that he does. I'm going to issue a shameless plug, which is I represent a lot of U.S. Law Shield members, and Law Shield has me come out a couple times a month and teach 2-hour classes on the use of force and deadly force. And we spend a good 15 minutes on brandishing because there's a lot to cover there.
we had an old VCDL member who's now passed, but he got charged with brandishing a finger because he was open carrying while he was arguing with somebody at the ferry in Surrey. And he's like, you weren't there. And they charged him with brandishing a finger.
He got out of it, but he had to go to court.
Yeah. And it was a tough fight. I went down there to watch it. It was a tough fight. And you think
That was a very corrupt county.
To answer the follow-up question there, which is brandishing even as self-defense, there's really two ways you defend a brandishing case, and you've got to sort of pick your method. You've got to pick your poison here. Defense number one is we didn't brandish a firearm. We didn't do anything that caused somebody fear with a firearm. We should not be charged because it wasn't us. We didn't do it. The second way to defend a brandishing case is to say, yes, we brandished the firearm. We pulled the firearm out. We pointed at somebody else. We did it on purpose. We did it because we had to. And that's your self-defense argument. Again, that's an affirmative defense to the brandishing charge and something that you can raise at trial.
Let's see. People ask quite a bit about carrying in a car if they don't have their handgun permit. You know, whether it's got to be a sealed container or a locked container or a closed container or a glove box or all of that. I remember an old gun attorney that doesn't practice anymore, and he once looked up in the laws that the word secured does not mean locked. It's kind of like, because he looked up how many times it said a child must be secured in a child safety seat, but it doesn't mean they had to be locked in the child safety seat. And he basically told me like this. He says, if you take a tennis ball and put it in this container in your car, and then you do a loop and a roll in your car, and the ball is still there, the ball was secured. So if you have a firearm secured in your vehicle in a center console or a glove box or whatever else, you don't need a permit to carry it. And then people like, even with a round chamber, even with a magazine, even with 5 clips, with all the other extra stuff. But the answer is that you can carry in a glove box or a secured container with no permit, correct?
And I actually have an article on my website where I talk about the case law governing this, but Gilbert and I were talking earlier today. There was actually a Court of Appeals ruling that came out this week that expanded that to a zipped up backpack in a vehicle. And that is very recent case law. I don't have the case number in front of me, but it came out, I believe, on Monday of this week was the ruling.
And the other thing John and I talked about with respect to that case in particular is it's great that it expands the exception for having a firearm in a secure container within a personal motor vehicle. But if you're going to put the firearm into a backpack, into a zipped up backpack inside your vehicle, and you don't have a concealed handgun permit, you need to really have your head on your shoulders, because as soon as you get out of the vehicle and you grab that backpack and start walking around with it, you may have forgotten that you put the gun in it, but you're now committing a crime. And so you need to be very, very wary. And I can see how this could get otherwise well-meaning people in trouble. And so that's not to say don't do it. It's just to say use your head if you're going to use this exception.
Yeah, this is not like the complaint that they're having down in North Carolina about people going down there to, go to the seashore and enjoy it. And then they leave their gun in the rental property. You need to know where your gun is at all times. You need to know where that is, just like you know where your wallet is fully at all times.
Now, I see that there was another follow-up here to the brandishing question. We should put a cap on that. It said, so we need an attorney. Her pretrial is tomorrow. The answer is yes, you do. Given that brandishing is traditionally charged as a misdemeanor, I'm not sure what you mean by pretrial. You definitely would want to talk to someone who works in this area. And I think Gilbert would agree there's only a handful of us statewide that really focus our practice on firearms related issues. And you definitely want to talk to someone. It doesn't have to be Gilbert or I or any of the other, gun lawyers that are part of VCDL. although we would certainly, be more than happy to talk to you about the case. But you definitely should speak to someone before just wandering in there tomorrow. Absolutely.
Okay.
Yeah. Brandishing, as John said, it's typically a class 1 misdemeanor, which means it's punishable by up to a year imprisonment and a fine of up to $2,500. So it's not something to just brush off.
And Gilbert just answered the other question that people asked, by the way. Looks like Dave Stafford had asked, what is the probable penalty if I sell or transfer a firearm without doing any background check? That is charged as a class 1 misdemeanor, and you just heard what the possible penalty for that is.
All right, looking at self-defense, Bill Rogers asking if someone approaches you in a threatening manner, at what stage can you display or draw your firearm?
Well, I don't think there's a bright line rule. There's so much that goes into this and so much to think about. There's various concepts floating around my head. One of them is the 21-foot rule, which I urge everyone I talk to should not be called the 21-foot rule. It should be called the 21-foot guideline. The concept there that if someone has the motive, means, and opportunity to cause you harm, they're intending to cause you harm, and they're approaching you, once they get in the general vicinity of within 21 feet of you, they can probably reach you before you can draw a firearm and discharge a round. And so the concept, and it's a concept used by law enforcement, is they become an imminent threat. The problem here, and why I say there's so much that goes into this, is it's very, very fact dependent. It is a fact dependent analysis on whether you're going to be justified in drawing a firearm, and certainly whether you're going to be justified in then further using the firearm. Because you have to anticipate that even if somebody is threatening you, they're walking towards you, at the point you display a firearm, it's likely that they're going to change their tune and change the tune when they talk to the police as well, and say that they weren't doing anything threatening and that you're a crazy person who pulled a gun on them. So you need to be ready for that type of reaction. Again, as I said, we spend 2 hours in classes in person going through scenarios. So I urge people to take a class like that, whether it's with me or whether it's with somebody else, and consider those different scenarios. The other thing that I would say when we're discussing this type of scenario is the importance of situational awareness and the way you position yourself. Because if you are aware of your surroundings, you are going to do a whole heck of a lot to head off that threat. And you can position your body in a way that makes it very, very clear that you're not to be tangled with without actually ever displaying a firearm or drawing a firearm. And that may be a way to stop that interaction from escalating.
And let me follow up with a different question. So somebody's threatening me, they're coming at me, and I'm not quite there drawing a gun. What if I just tell the person without touching anything or making any motions, I have a gun, you need to leave me alone?
Sure. Well, that statement alone, is it possible they could probably charge you with assault if they wanted to? They could probably still charge you with brandishing if you do in fact have a firearm with you. Because again, the person's going to be telling law enforcement they threatened me with a gun. And when you do in fact have a gun, police are probably going to move forward with charges. So do you greatly improve your chances if you're not waving a gun around and can prove that you weren't waving a gun around? You do. You greatly improve your chances in the legal system. Is it possible that you'll still get charged? It's certainly possible.
Okay, so we have a question on duty to retreat. My understanding is that you only have a duty to retreat if you are a part of the problem that led to the threat. No duty to retreat otherwise.
I think one of the things when people come to me and they want to talk about duty to retreat, as Gilbert said earlier, people crave a bright line rule. And unfortunately, we don't have a bright line rule for pretty much anything where self-defense is concerned. I will say this, as Gilbert pointed out, Virginia will allow you to use self-defense in defense of life or limb. of yourself or an innocent third party. They will not allow you to use deadly force in defense of property. And, you know, the reality of the situation is, here's what I tell people when I teach classes. If you pull your gun, you are putting your liberty on the line, no matter how good the facts are. You have no idea who the police are going to believe or how it's going to be presented by the other witnesses there. If you pull that gun, you might literally lose your freedom. And if you perceive that the threat you are facing is so significant that you are willing to take that risk after evaluating it, then you've probably waited until you are in an appropriate position to at least present a firearm. If you have any doubts, even if you have no duty to retreat because you literally had nothing to do with what's going on, that doesn't mean that strategically or tactically it's not the appropriate thing to do. Unless you are leaving yourself or a member of your family or an innocent third party that you're determined to protect in an untenable situation, I would advise people to always retreat if they can safely do so.
Absolutely. And you improve your chances if it does become a legal fight. If we get to tell the judge or tell the jury, you tried to get away. You tried to get away from this other individual. Even if you're not required to take that step, that looks really, really good for you. And so that is a helpful fact. And so my go-to line, I tell people it's good practical advice, and I think it's good legal advice in Virginia, is an armed society is a polite society. And this is where I see people getting involved in things. They escalate altercations and then say, I have no duty to retreat from this, and you may have a duty to retreat. If you're getting involved in something, you might have a hand in starting the altercation. You might be legally duty bound to retreat. And if you don't retreat, you might take self-defense off the table completely as a legal claim that we can use. And again, if we remove self-defense as a matter of law, if you can't use self-defense, then we're back in that other world, which is, it wasn't me, I wasn't there, I didn't do it, you got the wrong guy. And that's often a losing defense. And so, be smart. If you can retreat, you should. Don't get involved in things that are going to escalate. Don't provoke problems. And if you're going to be responsible and carry a firearm, let someone say something rude to you. Walk away from it. At the end of the day, it's no skin off your back. And that's what I urge everyone to do.
What I typically tell people is the fight, especially the gunfight, the only one you're guaranteed you're going to win is the one you never get into. The other guy could have a 1 in a million shot and that doesn't even practice. First time to shoot a gun and he did a bullseye. And the next question, by the way, is probably for you, Gilbert. The question is, what dollar amount should we have for coverage in this crazy world today?
And that is actually definitely for Gilbert, and I'll leave that with him. I just wanted to finish one other comment about the previous one before we move on, and that is, let's say that you are in fact not the one that caused the problem. I defended someone a couple years ago. They were in fact attacked, unprovoked. They managed to flee, escape the situation, the adrenaline kicked in, their pride kicked in, they went back. And because of that, we ended up not having a good day in court. Okay, so you can absolutely be an innocent victim and convert yourself into part of the problem. Once you've escaped, keep escaping. I just wanted to finish that way, and I'll turn the question about coverage back to Gilbert.
Yeah, the reason they're turning this over to me is because, as I told everyone earlier, I've represented U.S. Law Shield members for several years. One of the big things that I think is beneficial about U.S. Law Shield is they give me the tools. They don't cap how much they're willing to spend on a case, and they have the resources to do it. And so that is a very, very beneficial thing to have on your side. To take that a little bit further, I don't think that there's a straight answer to this either. I don't think that there's a dollar amount that we can ever point to and say this amount is sufficient, because we don't know. Every case is different. Frankly, media attention is going to have a giant effect on how much is going to get spent on a case. because all of a sudden, if the media fixates on your case, you might expect special prosecutors to be brought in. There's all sorts of stuff that can go, and you don't know where it's going to go, and you don't know how much effort it's going to take. So I think it is prudent to at least be either putting money aside and prepared, or thinking about one of those coverage plans that is out there, having something to help back you up in case, because frankly, an accusation alone can do it. You might not brandish a firearm, but if someone says you did, that might be enough to get you into the legal system.
I think one of the things you guys might address, it was certainly a surprise to me a few years ago when I learned about it, I'd never had to deal with it, was bail, and how you have some way to cover a bail, especially if they hit you with some large dollar amount because it was a shooting. I bet you a lot of people have no idea how the bail system works and how much money is going to come out of your pocket and how important it is to have some way to fight back. If one of you could address that one.
Well, I'll start by saying I don't think that there's any guarantee that you're going to be eligible for bail or bond. In most of these cases, if you've shot somebody else, the criminal charges that you're going to be facing are going to be what we call presumption charges in Virginia, meaning that there's going to be a presumption against bond. And this shocks people because a lot of times people involved in self-defense incidents are people, they obviously didn't leave their house planning to have a self-defense incident. It wasn't like they left planning to go rob somewhere and then are pretty, ready for it when the police show up. They left their house going about their day as normally. Somebody attacked them, forced them to respond. Now they are charged with a presumption offense. And a presumption offense means that when you get taken down to the police station, the magistrate is not going to release you that night because there is a presumption that you're ineligible for bond. And in that situation, we're going to have to file a bond motion and put it on before a judge in order to get you out. The really difficult thing about this is that there are some counties where they only hear a bond motion, for example, on Tuesdays. Tuesday's the only day that there's a judge sitting to hear a bond motion. And that means if you get arrested on Tuesday night on a presumption crime, even if you've never been in trouble before and you have nothing else going on in your life and you've got kids at home and you've got a job that you've got to show up to, you're probably sitting until the following Tuesday when that judge is back in sitting to hear bond. And there's nothing we can do about it. There's nothing myself, John, any lawyer can do about it in that situation. Now, once there's an argument for bond, the amount of money that is required is going to vary hugely based on the facts, based on how culpable they think you are, based on your prior criminal history, based on your family ties to the area. These are all things that we get to argue and go into an argument over what your bond should be set at.
All right. I think a lot of times people can't afford to bond directly, so they end up having to put their house as collateral that they'll show up. And is it correct that the bond company gets to keep 10% of the amount of the bond, no matter what?
Well, if you go through a bond company, then yes, that is in fact the price of getting out. There are other ways to take care of a bond, but if you're going through a bond company, yes, that 10% is a sunk cost.
Yeah, so if you were in for that $500,000 bond, you owe them $50,000. That's a lot of money to come out of anybody's pocket. But that's sort of a gross example.
But if you put up the $500,000 yourself, then you'll get it all back at the end of the proceedings.
Okay.
And just to further clarify, that 10% is not a set concept. It is negotiable. It's pretty standard throughout the industry, but different people charge different amounts.
So a question that we get, again, pretty regularly is, one of your friends calls you up and says, hey, do you want to go get a cup of coffee? I'll meet you at the coffee shop. And you jump in your car and you get down there and you see a no gun sign or something that says it's a picture of a revolver with a slash through it. And I'm like, well, good. I'm not carrying a revolver, so I'm good today. Do those signs have the force of law?
It depends on what you mean by force of law. Do you mean, are you going to be charged with a Virginia firearms crime for going on to private property that has a no firearm sign? The answer is no. Now, could you possibly be charged with something else? That's a very fact-specific inquiry. Have you been warned before by this private property owner who actually caught you carrying a firearm and told that they prohibit them? In which case, you have been trespassed before, meaning you've been notified that they do not wish you to come there while carrying. And then if they catch you doing so again, they can have you charged with trespassing in violation of their wishes. But they do not have the force of a firearms charge.
Thank you. I think that was I just didn't phrase the question right, but that's kind of what the general question has usually been.
So that would be different if that no gun sign you saw posted was on, say, a government building starting July 1st.
Very much.
Funny, some of those, they have the slash. It's like, you know, it's a red circle with the slash, and then on the outside of the slash is a knife and a gun. So it kind of looks like you can have both. Let's see. So coming up on 10 minutes left to the hour. Is anything that any questions that John, that you or Gilbert get in your practice on a regular basis that you're like, oh, I can't believe I got this question again. I'm just going to play the pre-recorded announcement.
Well, simply because I know it's coming, even if the questions aren't hitting yet, is what's going on with federal gun control, with the changing definitions of firearm laws and changing definition of firearm itself and firearm frame or receiver. And so that's absolutely something that's coming. Right now, the Biden administration has really targeted two different ideas. One is their current, somewhat admittedly poor definition of firearm frame or receiver, because they have some issues with that definition. Now, whether the steps they're taking is going to fix anything, I don't know about that. But they are going to probably make a change there. The other thing that they're targeting is what has been referred to as 80% lowers, ghost guns. They're now calling it PMFs, or personally made firearms. And they're going to come after both of these are going to be things that we're going to see federal attention directed towards. In addition to that, we also, and we were all sort of joking about this before it got started, currently there is a nominee that Biden has put up with Mr. Chipman to direct the ATF. And there is, for very, very good reason, a lot of concern within the firearms industry about this nominee. And where I'm going with this is all three subjects right now, we have the opportunity to contact legislators and push on. And now is the time to do that, because if we wait and we push after these changes go into effect, or we try to push after this individual gets, receives confirmation in the Senate, it will be far, far, far more difficult to undo the wrongs that occur in court than it will be to have legislators do something about it now.
There's a question that's come up, and I'd like to ask and get your answer, but I have a sort of an add-on to this. Jonathan Luna notes that this is depressing to hear. It sounds like gun control advocates already won. Well, I think first of all, our self-defense laws go all the way back to the founding of Virginia, at least for the state of Virginia, the Commonwealth of Virginia. And indeed, most of this is about making sure that you're not committing murder and trying to get away with it. I think that's a lot of the reason we have this. But if you are falsely accused and you end up, getting out of it because they figure out they lied about your brandishing or whatever, what is your recourse there? How do you strike back at somebody that's just really put a wrecking ball on your life? Can you sue them for civil claims? Can you take them to court? Will the police arrest them for lying to get you where you're at? Well, what happens?
John, you want to take this first? Or?
You're right. You have the same look on your face that I do. In order for someone to face, and this is an unfortunate fact, in order for someone to face real consequences for making charges that are unfounded or false requires a level of evidence of the falseness of those accusations that goes far beyond what probably happened to get the charges dropped. So the reality of the situation is, and we see this not just in firearms cases, but in domestic cases and assault and battery cases and sexual assault cases, things like that, where people are, sometimes the accusations are incorrect. And when that happens, it oftentimes destroys lives. And in most cases, unfortunately, the consequences are not there for the person who made the false accusation. And that's a horrible thing to have to say. But again, we have these rules of evidence. We have the way that we prosecute these things for a reason. And sometimes things slide through and people are hurt without recourse. I'll turn it to Gilbert to add to that.
I don't think there's a lot to add other than it's a high bar. It's a high bar to get over to actually see somebody be prosecuted or even have civil recourse against somebody who lied to get you criminally charged. And unfortunately, and this is why this presumption of innocence is so important in this country and often so underappreciated and so little recognition given to it. Because it happens every day. People get wrongfully accused of stuff. And certainly, are there situations where people that did do bad things walk away? Yes, there are. I'm not going to say it doesn't happen. But there's also a lot of situations where good people who have not done anything to deserve what they're going through get prosecuted. I'll tell you just on a very personal note, I see this occur with people in vehicles more than anything else, because if you're in a vehicle and maybe you inadvertently cut somebody off and you happen to have a Sig Sauer sticker on the back of the vehicle, now you've given the person who you just accidentally cut off, and again, you didn't mean anything by it, but you've given them a pretty big hint that you're a gun owner. And if they decide to call the police and say the guy in the black truck with this license plate pointed a gun at me, and 6 miles up the road, you get pulled over by the police and they say, do you have any weapons in the vehicle? And they're acting pretty tense and you have no idea what's going on. You're probably getting arrested that day, because they're going to say, well, the presence of the weapon in the vehicle corroborated what the other person told us. Oh, and they described the weapon, by the way, it was a small black handgun. Well, yeah, what are the chances? And they're going to haul you off. And so it certainly happens, and it's something you need to be aware of.
Well, Ed would be safe with his little red gun. They wouldn't think to name that color. But what about a civil suit? I mean, they say you can sue somebody for almost anything. Can you civilly sue somebody for what they've done to you?
Well, you can sue someone for almost anything. You can't successfully sue someone for almost anything. Again, I think Gilbert said it right. I think that even civil options are very limited unless you have just overwhelming evidence of the actual misstatement.
And frankly, lots of money, because lawyers are going to charge you lots of money for that civil suit. And to see it through the process, it's not going to be financially viable for you in most situations.
Okay, question came in about full metal jacket bullets. Is there a positive or a negative to using full metal jacket? And of course, part of that may also deal with caliber.
Over penetration. That's the only word that comes to mind with full metal jacket.
But you have 380, you may need that. Even the full metal jacket may not over penetrate. That's what I'm saying. Caliber could matter there, or 22. But generally, for self-defense calibers, like most of us carry 45, 9, 40. Full metal jacket's probably going to over penetrate.
Yeah, the only place where full metal jacket might be a good idea to carry, in my opinion, is if you are carrying under HR 218 or LEOSA as a law enforcement officer and heading to a place like New Jersey. That's the exception to the general rule, which is the general rule being hollow point ammunition makes sense because it's more effective at stopping the actual threat and less likely to go through the threat and hurt somebody else.
And I think there's an ammo that they make, and I don't remember who manufactures it. That's a hollow point, but it's got a full cover over it. And so this gets around the New Jersey law because it's basically a FMJ. I mean, yeah, an FMJ that somehow magically can expand under the right conditions.
Well, I have a friend named Evan Knappen, who's a very, very successful and very high profile firearms attorney in New Jersey. And Evan has successfully defended cases where people were otherwise lawfully able to carry the firearm in New Jersey and arrested for having Hornday critical defense or critical duty ammo, which has a polymer filling in the tip of the ammunition. And the point there is New Jersey still arrested people over it. They were successfully able to defend it and get charges dropped or dismissed. But New Jersey is not gun friendly. And unless you've got an exception like, and when we're talking HR 218, which is also known as LEOSA, that's an exception for current or former qualified law enforcement officers. Unless you fit into an exception like that, you basically cannot go into New Jersey with a firearm. And again, there are small exceptions in the law, but as a general rule, stay the heck out of New Jersey.
And you brought up something I think that's important too. Let's talk a little bit about traveling interstate under the federal law, where, you know, if you're going from a state where you can own and carry a gun to a state where you can own and carry a gun, the gun's unloaded, ammunition is locked separate from the gun, out of reach. You can still fall into problems with that in states like New York, can't you?
They have taken the position in a number of prosecutions that that is an affirmative defense that can be raised at trial, not an exception to arrest.
So you take the ride, but in theory, by the time you get in front of a judge, then you can call this up and say, yeah, but I shouldn't have been charged, and they drop it. Meanwhile, you've been in jail, you paid a fortune to an attorney. You've probably, if you don't have hair my color, you'll have hair my color by the time you deal with this. And so that's like New York. Do you know any other localities that are pulling that baloney?
I believe Maryland had somewhere around a decade ago, there was one or two cases where Maryland had done that a couple times, but New York, New Jersey, Maryland, there may have been some in New England, like Connecticut, Massachusetts, but I don't know for certain.
I do know of an organization that sells a travel guide on their website, VCDL.org, and you go under gear, and we've got a travel guide that gets updated every year. It's not the catch-all everything, but it's pretty well updated to just kind of give you an idea on what the gotchas are and what to look out for.
And so, and guys, what about them talking about that? What do? You're pulled over in New York, and they say, "Have you got a gun in the car?"
Well, there's a comment over on the side which says you might want to mention to never consent to a search of your vehicle, and I might add, never consent to a search of anything, not just your vehicle. Do not consent. And you know, I sometimes joke with people that think consenting to a search wouldn't be that big a deal. And I say, I hear you, but do you know who owned the car before you? Because what if something did slide down between the seats that you've never found and the police find during that search? You bought the car new, great. Have you ever transported teenagers in it? You 100% confident that those teenagers never brought anything unlawful into that vehicle? Because if you consent to the search, you take away arguments that we can use to help you down the road. Now, there are some states that have legal requirements that say when you come into contact with law enforcement, you have an obligation to inform them of the firearm. I think that there are, especially if you were unlawfully carrying in those states, there's a Fifth Amendment collision with that requirement.
Okay, so that would be important, like in New York, they're pulled over, and the point is you would never lie to the police, but you don't have to answer the question. Would you say, I'm taking the Fifth, or would you, maybe just change the subject? How would you handle it if you were?
I would probably try to change the subject and tell them where I'm going. I'd say, look, because again, you can't be staying in the state. That's something the law, and we can put this in the comment block. The federal law we're talking about is 18 USC 926A. That's where you're going to find it. I encourage people to read it and take a look at it. It's pretty short. It allows you to go from one place you can possess the firearm to another place where you can possess the firearm. It does not allow you to stop and stay. It has a couple of other requirements. But in this situation, I'm driving through the state of New York. I'm going to somewhere else. I'm going to New Hampshire where I can legally possess the firearm. I would change the subject and say, officer, I'm on my way to New Hampshire. Unless you've got a reason to hold me here, I don't want to answer any other questions about my day.
I like that.
And in Virginia, there's no requirement for you to notify that you're carrying in Virginia.
Not in Virginia.
There is in North Carolina. I mentioned that just because they're a neighboring state that a lot of people out there go to frequently, including our governor, but he won't stay there.
Well, I think we got all the questions that we had on the list, and we're at 9 o'clock. Maybe we'll just go around the room and let everybody say their spiel and what they want to say, and then we'll say goodnight.
Oh, we'll start with the attorneys.
Well, I'll just say it's been a pleasure to be here today. I just want to follow up with Jonathan Luna, who was talking about how this was depressing to hear. And I just want to point out that as attorneys, Gilbert and I are charged with keeping people out of trouble. We have to say, these are the worst possible things that can happen. To a certain extent, we're like insurance underwriters, right? What's the worst thing that could happen? Well, your house falls into a sinkhole and completely explodes. So when we're talking like this, we're fulfilling our obligation to try and give the best advice we can to keep people out of trouble. In reality, however, Virginia, compared to places like New York, New Jersey, and other places where the anti-gunners have gotten their way, is an absolute paradise. And 99.9% of that is because of this organization right here, VCDL, and the work that they do every year. And so please don't give up on Virginia or VCDL or on the ongoing fight. You know, we have to get up every day and we have to fight back against the additional attempts that the anti-gunners are making to make the environment worse for law-abiding gun owners. And I really appreciate being able to speak to everyone. And if anyone has any firearms law related issues or gun trust issues, I'll be glad to help them. And I'll turn it over to Gilbert.
To add on to what John was just saying, I totally agree. We often look at worst case scenario, and we look at things that way, not just because we have an obligation to, but also because on a day-to-day basis, this is what John and I do. So we get to hear the horror stories and the worst case examples and how terribly people get treated by the legal system at times. And so for that reason, it's at the forefront of our minds. But to echo John's sentiment on this, I don't think that we should look at what's going on in the world and say gun owners are losing. I absolutely don't think that's the case. In fact, we can look at the map of where you can carry a firearm, and in many respects, freedoms that we originally had at the founding of this country that were slowly taken away are starting to slowly come back in many places. And that's very, very exciting to see. That's very, very good to see. That being said, we know that the struggles we have, we understand the struggles we have here in Virginia. We're aware that we've got major struggles, and we're aware that you have to constantly be vigilant and constantly be active in order to combat what would otherwise be the legal situation here in Virginia. And so don't get discouraged. And I tell people this when I talk in firearms classes as well. I never, ever, ever want anybody to leave my class saying, I'm not going to carry a gun anymore because there's too much danger. That's not the goal. Carrying a firearm is an important right. It's an important responsibility. And we flat out know that if you're not going to be responsible for yourself, no one else has to do it for you. So I want you to be responsible. I want you to carry a firearm. I want you to go home to your family at the end of the day. These are all things I want for you. And so I want you to keep doing it. I want you to be vigilant for your rights, because a lot of people sort of, especially on the other side, poo-poo this whole idea of the slippery slope. But the slippery slope is very, very real. And when you start making concessions on little things, you will find that they're just going to keep chipping away, chipping away, chipping away. So stay vigilant, stay involved. And as far as constitutional rights go, the protections that we have for firearms were considered critically important by our founders because they understood how the right to firearms safeguarded all the other rights. And so not only in your personal life to make sure that you're safe, but for our country as a whole, these are rights that are worth protecting. Thank you so much for having me on.
And I think what you two said is really important. And I think, for example, I think it would be very inappropriate for somebody teaching somebody to drive an automobile to tell them, oh, well, there's almost no chance that you could ever get killed in a car. You know, you probably won't even get hurt. Well, because we know that's not true. So you want to make sure the person understands that if you don't do things right, there is a very real chance you could die. That doesn't mean you don't drive a car, but it means you're aware, and you need to be aware of the worst possible scenario. Because Murphy, that the Irishman that brings bad luck to everybody, gives him the worst case scenario. He's always around, so you got to watch out for him. And I guess I want to say at this point, I want to say, you guys are examples of why a VCDL is what it is. We've got fantastic attorneys, and they play a critical role in the day-to-day running of this organization and knowing what to tell members, what we can do legally as an organization. It goes on and on and on. And they're a sample of what we've got in the organization. It's a secret weapon, and that's a wonderful thing. And I thank both of them for all the time that they dedicate answering my questions, answering the board's questions, helping gun owners. It's we're blessed. That's all I can say. And I want to thank everybody that's here watching this for doing so. And hopefully you've learned something. I know I've learned plenty.
Well, so it's like I saw Benjamin. Benjamin said VCDL needs to promote this session as a must-see thing. There's so many new gun owners who need to hear and understand this info. And we agree. So share this video, share it on your own social media, get to it off our YouTube, give it to your gun owning friends that might not even be able to watch it while they're driving to work, but they can just play it through their car audio and just listen to the audio so they gain that knowledge on the way to and from work. Encourage them to join the VCDL. You can do everything from our website. You can join, you can renew. We've got family memberships, a lot of things going on at vcdl.org. Donate, everything. So thank you all for joining us.
Yes,
Matt?
thank you all. I want to say thanks to John and Gilbert, especially for taking the time out of their evening away from their personal and family lives, and to Philip and Ed for arranging this. But you guys just, it's really humbling to know the caliber and of people that volunteer for VCDL. John and Gilbert are the tip of the iceberg. They're an awesome tip of the iceberg. But we have a lot of lawyers that volunteer their time and offer free legal gun advice to VCDL and to members, to help people stay on the right side of the law and to maintain their rights and to advance their rights. We have a lot of members that also do volunteer work, working at gun shows, spreading the news, teaching other people how to shoot, working at ranges, volunteering their time in all sorts of different ways. So there's a ton of ways for people to get involved and to help advance and regain some of the rights that we've lost. Constitutional carry is a big one. We will continue to push for that. And we'll continue to defend your right to defend yourself, just like we've always done. As Ed said, share this video, let people know what we're about and how they can get answers to their questions.
And vote in every election.
Yes. And thanks for joining us, folks.
Thank you, everybody. Good night.
Good night.
All right. Well,
Awesome.
Appreciate you guys. Thank you, Gilbert and John. Good stuff.
It was a really great event. Hopefully, if we helped any members, it